Hello, welcome to the Hukum Info. In this section, we are going to talk or we are going to discuss about the fundamental differences between legal entity and non-legal entity. Actually, this discussion came from when I was in the conversation with my friend. My friend talked to me that he wanted to make or establish a business, but he's still confused. What kind of business, what kind of business entity that he is supposed to make? After listening to his considerations, then I got the point that the reason that makes him confused is or on the capital, is on the capital. He said that actually he wants to make this business in form of limited liability company. But he thought that the capital of making limited liability company is much higher than making firm. That was why he became confused and become confused of which one is the best. After that, I said to him that actually the reason or the main consideration should not be on the capital, but it should be on what kind of categories is the legal entity included. Let's we talk more about that. Based on the theory of law, there are two kinds of categories. First, legal entity, and the second, non-legal entity. Legal entity means an association of individuals committing the same job and having the same purpose and which has fulfilled the requirements required by law, which having assets as well as rights and obligations that have been separated from the members or the owners. Based on the definition I talked to you previously, then we can see that there are two fundamental elements of legal entity that make it different from the other. First, having assets being separated from assets of the member or the owners. And two, having rights and obligations that are also separated from the members or the owners. This thing certainly will bring the consequence that in the event of this legal entity one day gets lost, then the creditor has right only to collect the assets of the legal entity, not included the assets of the member or the owners of such legal entity. Why? Because between the legal entity and its owner or its member has been occurred the separation of assets, has been occurred the separation of rights and obligations. And in other side, this thing does not apply to non-legal entity. In principle, non-legal entity is the opposite of legal entity. That is to say that there is no any separation of assets, there is no any separation of rights and obligations between this non-legal entity and its owner or its member. Therefore, when one day this non-legal entity gets lost, then the creditor has right not only to collect the assets of the non-legal entity, but also including the assets of its member, of the member or the owners of this non-legal entity. Right? And then I want to tell you about the legal entity. I want to tell you about these kinds of business that are categorized as legal entities, such as limited liability company, corporations, and foundations. Those three are categorized as a legal entity. And while kinds of business entity that is not categorized as legal entity, such as trading business, limited partnership, and firm. So the conclusion is, legal entity has its own assets and rights as well as obligations. There existed the separation of assets between the legal entity and its owner, while non-legal entity has no its own, while non-legal entity has no its own assets and rights, as well as obligations, what becomes the assets of its owner or member is also the assets of this non-legal entity. Okay, that is the end of our discussion now. I hope this will be useful for you, and thank you very much.